Hello and welcome to Freedom News, the news you can use to help keep Canada free. I have for you an article that was emailed to me by CanadianCitizens.org entitled Omar Khdar and Canada, a Misinformed Love Affair. It goes on about the disgusting interview he had on Radio Canada. We saw there on that French television show. I will, of course, spare you that nonsense. Of course, we all know how evil and disgusting that was. I'm going to give you some facts that don't make it out into the mainstream media all too often. The other, less popular side of the story. It goes on to say, one could be forgiven for sensing that all evidence and factors driving the Khdar case justify his award of $10.5 million as compensation for Canada's abrogation of his charter rights. After all, we have been told that by Supreme Court ruling and by the Prime Minister himself. To summarize, the award was that made Mr. Khdar a rich man and took attention away from his confessed crimes was based on three claims. That young Omar was a child soldier, that his due process charter rights were infringed upon, and that he was tortured while imprisoned in Guantanamo. Well, let's take a look at these claims, shall we? Was Khdar indeed a child soldier? Well, in accordance with the related conventions in place at the time of his capture, Mr. Khdar was not a child soldier. It needs to be noted that Mr. Khdar was plucked from a foreign battlefield in July 2002 by American forces and was subject to the international laws of war in place at that time. These conventions regard the designation of a child soldier were based on Geneva Convention protocols from 1949 and 1977 that prohibited the recruitment and use of children under 15 for military purposes. Omar Khdar was a few months shy of 16 when captured. The definition of child soldier would change to denote age 18 when the optional protocol to the Convention on the Rights of the Child on the involvement of children in armed conflict. But the United States would not ratify this treaty until after Khdar was captured. At best, then, he could be considered a youth at the time of his capture, but still eligible for treatment as an adult given the nature and severity of his crimes. Additionally, he could not be considered a soldier under these same conventions as he was an unlawful enemy combatant. As such, he could not even be considered to be a prisoner of war, but rather an irregular subject to trial by military tribunal. Claim number 2 we're calling into question. Were Khadar's chattel rights abridged? By addressing the second claim, it is important to note that charter rights are not intended to be a suicide pact. There is an important distinction here that speaks to the fact that charter rights need to be responsive to wartime considerations that include matters of heightened national security and public safety. It is these special considerations that inform Canada's treatment of prisoners of war and dictate the need to militarily detain such individuals until the cessation of hostilities. Individual rights and freedoms need to take a back seat in such circumstances in line with the Charter's Section 1 Reasonableness Clause. The Charter cannot be seen to sanction the release of POWs back onto the battlefield or onto our streets to create mayhem through acts of war, or, in Khdar's case, jihad. Given the premise that Khdar, by virtue of his POW status, was not privy to a full set of rights and freedoms afforded a citizen, Canadian courts would have been more fully informed had they considered the law of war that pertained to Khdar's detainment and to which Canada was a signatory. Indeed, related Canadian Forces doctrine dictates that the interrogation of combatants, unlawful or not, shall always be conducted as if the subject had prisoner of war status. It is important to note that this status does not afford the prisoner a right to have a lawyer present during such interrogations. In the matter of torture, this same doctrine is adamant that a prisoner not be subjected to unpleasant or disadvantageous treatment. At the same time, however, it requires that allegations of ill treatment be supported by evidence that establishes proof of such beyond a reasonable doubt. Should civil and criminal courts be subject to such considerations before they wander from their high, safe benches onto the battlefield? After all, there is much at stake in the way of national security and public safety if they don't. Claim number 3. Was Khdar tortured? Allegations of torture in Khdar's case were floated by an affidavit that originated from the Khdar legal team. These allegations were investigated by the military judge Patrick J. Parrish, who determined that no evidence existed to support the numerous accusations. All this to say there was no basis to conclude that Khdar was the target of mistreatment. This assessment was reinforced when video evidence was uncovered that proved Khdar took part in the building and implanting of IEDs. It was at this point that Khdar refused to take the stand and subjected his claims of torture to cross-examinations. It was also at this point that he confessed to his crimes. At the end of the day, it can be said that Khdar was an unlawful enemy combatant who confessed his crimes due to the evidence against him, not because he was tortured. It can also be said that his right to charter protection should not have been automatic, but informed by laws of war that serve both combatant and civilian populations. Neglecting such obligations may serve one's virtue only to destroy another's security. Well, that's all I have for today. Like if you like, share, comment, and of course, subscribe. And remember, working together, we can help keep Canada free. Thank you, and have a good day.